Justice Sotomayor?
Counselor, we haven't gotten back to the main question that amicus has addressed. You agree with petitioner that 2244B1 applies only to state prisoners, the same claim litigation bar, correct?
That is correct, although we may have slightly different reasons for concluding that. I think some of it overlap, but they don't apply onto all of our...
But you disagree with amici position.
That's correct.
Why don't you just summarize why you disagree with amici?
Well, I think there's I'll give you a preface, and then I'll jump to, I think, a more dispositive point. First, when you look at the language that's used in B3 and B4, the language is distinctive from B1 and B2. It uses second or successive application, and it uses authorization language. Both of those map directly onto what H is doing. That is bringing a federal prisoner.
Just go back to it.
And then the second point is, even if most of the amicus's argument turns on the fact that B3C says you look to the prima facie requirement with respect to the requirements of this subsection. Subsection B includes B1 and B2. Even if you accept that you look to the subsection, when you look at B1, by its own terms, it only applies to a habeas corpus petition under Section 2254.
So
it just wouldn't even apply on its own terms, even if
the bottom line is you agree substantively that the Court of Appeals, the District Court and the Court of Appeals, or the Court of Appeals, did not subject this to the proper review. It should have reviewed it under...
Yes, and this has been the Department's position before any Court of Appeals took that.
All right. Yes, you've been saying that from the beginning. But you're claiming that this is unlike Castro and that we don't have jurisdiction even under the narrow reading, which is the Castro reading by your...
That is correct.
By your adversary.
That's correct.
Does that make any sense? There has been no review of the merits of this case at all by the Court of Appeals.
Justice Sotomayor, the jurisdictional inquiry does not look to whether there's an error and then decide whether
they used it that way. They refused to apply 2255H by dismissing the case. They didn't deny the application as not newly discovered evidence or not a new rule of constitutional law. They dismissed the case instead of denying it because they said they lacked jurisdiction.
That seems to support my point. Their point was not that it doesn't – we're not going to address whether he's right or wrong, the prisoner is right or wrong. We just lack jurisdiction. The same thing is true here.
Well, if they didn't lack jurisdiction, they got the ground wrong. That's what basically
I've not seen any decision by this Court that
By the way, there's no question that if he goes back down and they look at it substantively, they'll probably boot him out anyway. But it wouldn't take care of the circuit split.
It wouldn't, but as we've discussed, there are other ways to take care of that. Just because this vehicle comes to you doesn't mean you need to pull the trigger immediately, particularly when there's a jurisdictional bar that would, if you rule against us on the broad ground at least, would triple the number of filings by prisoners.
No, it wouldn't, because all that would have to happen is that circuit courts would just say we're granting or denying under H, and that's clearly barred. That's what they should be doing anyway, but they're not doing. Some of them are using the state habeas substantive provisions instead of the federal habeas substantive provisions.
Well, we agree that there's an error there, but I don't think that error...
There wouldn't be an increase in filings. Castro hasn't increased our filings. They would just do what they're supposed to do. Say under H, deny.
Well, that's because Castro is only the question of whether it's second or successive, and in this case, there's no question it's a second application. It would be his second.
But it would only be with respect to B1, a ruling by us.
Justice Kagan?